parts of the law the administration intended not to follow. Importantly, we learned that Judge Gorsuch advocated for the Bush administration to issue a broad signing statement. He said it could be used to, and I quote, help inoculate against the potential of having the administration criticized sometime in the future for not making sufficient changes in interrogation policy in light of the McCain portion of the amendment. This statement clearly and in a formal way that would be hard to dispute later puts down a marker to the effect that the view that McCain is best read as essentially codifying existing interrogation techniques. Nothing could be farther from the truth. Judge Gorsuch's email shows a knowledge of the Bush administration's position on torture. It also demonstrated he supported efforts to codify existing interrogation policies, such as waterboarding and other extreme techniques. In our written questions, I asked again about his views on enhanced interrogation techniques. I know something about them. The Intelligence Committee, while I was chairman, has in classified stata over 7,000 pages with 32,000 footnotes that document all of this. I tried to understand his opinions on right and wrong and whether he was at all disturbed by what our government was doing. Unfortunately, once again, the answers I got were non-responsive. For example, I asked Judge Gorsuch what he meant when he suggested that a signing statement could inoculate the administration if they were later criticized for not making, quote, sufficient changes to the interrogation policy, end quote, based on the McCain amendment. Judge Gorsuch responded once again that he was, quote, a lawyer advising a client, end quote, and that his client, the government, was arguing that the McCain amendment simply codified existing policies. Judge Gorsuch's defense is that he was only doing what his client wanted him to do. Many of his colleagues, of my colleagues, on the other side of the aisle have praised Judge Gorsuch's qualifications. And there's no question he's well-educated and well-credentialed. But we're not just evaluating a resume. If we were, every Supreme Court nominee would pass unanimously, 100-0. Rather, all of us evaluate not only their education and experience, but also their judicial philosophy, temperament, and views on important legal issues. We do this because if confirmed, a nominee's decisions will affect the lives of all Americans for generations. And as I've said, our job is to assess whether the nominee will protect the legal and constitutional rights of all Americans, and whether the nominee recognizes the humanity and justice required when evaluating the cases before him. Unfortunately, based on Judge Gorsuch's record at the Department of Justice, his tenure on the bench, his appearance before the Senate, and his written questions for the record, I cannot support this nomination. Thank you very much, Mr.
Thank you.
Chairman.
Senator from Utah.
Well, thank you, Mr. Chairman. Before making a few comments about the nomination of Judge Neil Gorsuch, I want to remind my colleagues about the committee's traditional practice regarding Supreme Court nominees. That practice was memorialized in a letter signed in June 2001 by incoming Chairman Patrick Leahy and by myself as the then-ranking member on this committee. Mr. Chairman, I ask consent that that letter be placed in the record at this point.
Without objection, so ordered.
Now, the letter states, quote, the Judiciary Committee's traditional practice has been to report Supreme Court nominees to the Senate once the committee has completed its considerations, unquote. Now, this letter was cited several times last year by those demanding a hearing on the previous nominee, but it says nothing whatsoever about how the committee should consider a particular nominee. The best way to evaluate an individual nominee depends on many factors. And last year, we obviously faced some unique circumstances. Though this letter was irrelevant last year, it is certainly relevant now because we have completed our consideration of the Gorsuch nomination. Since only 5 current committee members were here in 2001, I wanted to make sure everyone was aware of our past practice. Now, the conflict over the Gorsuch nomination is not about whether our fellow citizens try to influence the president's nominations or the Senate's advice and consent. Of course they do, from both the left and the right. Anyone who thinks that specific left-wing groups have not moved mountains and spent like mad to influence past Supreme Court nominations has been living in a parallel universe for the last 30 years. Nor is the conflict over the Gorsuch nomination about whether President Obama had a right last year to appoint this nominee. No, President does. That's what checks and balances are for. The Constitution gives the President the power to nominate judges and gives the Senate the power, advice, and consent on those nominations. Both the President and the Senate legitimately exercised their respective powers last year. The conflict over the Gorsuch nomination is instead about 2 radically different ideas about the role of judges in our system of government. America's founders designed the judiciary to impartially interpret and apply the law. The judges did not make and cannot change to decide individual cases. The law, not the judge, determines the results, and the way to change the results is to change the law. The other idea is that deciding cases is a means to the end of judges addressing issues and advancing political interests. In this view, judges not only may, but sometimes should change the law so that their decisions produce politically desirable results. The judge, not the law, determines those results, and the way to change the results is to change the judge. Judge Gorsuch's supporters and opponents agree on one very important thing. We both believe that he will take the law as he finds it and apply it impartially, refusing to bend his decisions in light of who the parties are or which political interests might be affected. I believe that's why he should be confirmed. His opponents believe that is why he should not. That's why he should be filibustered. And like America's founders, I believe that such impartiality and independence help keep the judiciary within its proper role in our system of government. That role by design is necessary for the liberty that we now enjoy. Judge Gorsuch's opponents see impartiality and independence as obstacles to overcome on the path to a fully politicized judiciary. That is why they demand that he prejudge cases, pre-comment on issues, and take sides before cases even come before him. The Democratic leader repeated over the weekend that if a nominee can't get 60 votes, the solution is to change the nominee. At least that is his current position, the one he takes each time the White House and Senate are under Republican control. Put a different way, he wants the Senate to do as he says now, not as he did then. That is not a principle, it's just partisan politics, and it is a very poor guide for the confirmation process. The choice we face is between impartial or political judges, between judges who follow the law and those who attempt to control the law. Judge Gorsuch is, by any measure, a superbly qualified nominee who is enthusiastically supported by those who know him best, regardless of their partisan or ideological views. He will be impartial, fair, and open-minded. He will be exactly the kind of justice that America needs and that our liberty requires. And he has had support from some very liberal lawyers who know how good he really is. And I hope that this committee will support him, and I hope